Hi friends, in this video we are going to deal with the article titled Fundamental Rights, Right to Equality, Articles 14 and 15. The author of the article is one Ms. Venika Sharma, who after completing her BABL is pursuing LLM from Jamia Millia Islamia, New Delhi. To know more about it, let's quickly move on to the topic.
Hello everybody, my name is Venika Sharma and in today's video I'll be dealing with the Introduction to Fundamental Rights and Article 14 and 15 specifically. So let's start without any further ado. So, fundamental rights. The idea of fundamental rights was introduced to restrict the absolute power of the government. By this, constitution became more powerful than the government. This was also referred to as constitutionalism. Fundamental rights are dealt in Part 3rd of the Constitution, which starts from Article 12 and stretches till Article 35. So, Part 3 of Indian Constitution is rightly described as the Magna Carta of India. So, if we talk about Magna Carta, it was the first document in the world in which the fundamental rights were provided by King John for his people in 1215. Now, the idea of fundamental rights was borrowed from American Constitution. So, originally 7 fundamental rights were there in the Constitution that were right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property and right to constitutional remedies. Currently there are 6 fundamental rights. Right to property, the 6th one, the right to property was deleted from the list of fundamental rights and it was placed in the ambit of legal rights by 44th Amendment in 1978. So, right to property was deleted from Article 31 and it was inserted by Article 300A in Part 12 of Indian Constitution. Now we'll deal with the features of fundamental rights. So there are certain features, they go as follows. Number 1 is they are available only against the state. The fundamental rights, they are not absolute in nature. The third is they are not sacrosanct or permanent in nature. Fourth is that they are justiciable rights. By justiciable, it means that they are enforceable in the court of law. Fifth is that they are defended and guaranteed by the Supreme Court under Article 32, which states about the writ jurisdiction of the Supreme Court. Sixth is some are negatively worded and some are positively worded. Negatively worded are the ones that start with the nothing in this article of phrase. So let's start with it. Now, right to equality. The topic of right to equality, it stretches from Article 14 and till Article 18. So let's start with Article 14 first. So Article 14 clearly states that that the state shall not deny to any person equality before law or the equal protection of laws within the territory of India. The word person in this article, it includes both citizens as well as non-citizens. So now when we talk about this, let's talk about the first thing that comes to our mind, that what is equality before law and what is equal protection of laws. So let's start with equality before law first. It means that it is that the law is supreme and nobody is above law. This concept, the concept of equality before law, it was borrowed from United Kingdom from the concept of rule of law of A.V. Dicey. We all know the concept of rule of law. It was given by A.V. Dicey. So this concept of equality before law, it came from there. Now, rule of law has 2 concepts. The first one is absence of arbitrary power and the second one is equality before law. And this part is considered as a negative concept because it imposes restrictions upon the state. So the part of equality before law, it is considered as a negative concept, and it came from the the Indian Constitution borrowed it from the United Kingdom. Now let's move to the other part, that is equal protection of laws. So the concept of equal protection of laws, this is based on the principle that likes should be treated likely. Like you can differentiate between the people that are of different nature, but the like one, the people that have same nature and they are basically they are like in nature, you cannot discriminate between them. This concept we borrowed it from American Constitution, and the classification can be done Like under this concept, you can do differentiation, but it should be based on a reasonable classification and on the intelligible differentia. That is, you can, for example, you can take the concept of reservation. It is based on the equal protection of laws only. Now, there is a positive, like the equality before law, it was a negative concept, and comparatively equal protection of laws, it is a positive concept, as it allows the state to do reasonable classification. Now, let's come to a case. It is a very leading case and an important case of Article 14. So the case is E.P. Royappa versus State of Tamil Nadu, and the case is of 1974 Supreme Court. In this case, Justice Bhagwati, he stated that equality is a dynamic concept with many aspects and dimensions, and it cannot be cribbed or cabined or codified within traditional limits. Now there are this case was there. Now we'll discuss. There are various doctrines under this section, and let's discuss them one by one. So the first one is doctrine of natural justice. So, however, this doctrine is not expressly mentioned under Article 14, but it is impliedly there. This doctrine emphasizes on the rule against bias, which is like a fair hearing. So, there was a case in this doctrine. It was Tata Cellular versus Union of India. It was a 1994 Supreme Court judgment. It was, in this case, it was held that every state action, whether executive or legislative, it must be just, fair, and reasonable. And it was also laid that the doctrine of natural justice is impliedly a part of Article 14. So it was laid in this case. So we are done with this doctrine of natural justice. Now second one is doctrine of arbitrariness. It states that any arbitrary action against without any reason against any person, which is without any reason, it will be violative of Article 14. Like, you cannot take any arbitrary action against any person. So there was one case in this doctrine, Andhra Pradesh Dairy Development Corporation versus B. Narasimha Reddy. This was a 2011 Supreme Court judgment. The Supreme Court in this case held that Article 14 strikes at the arbitrariness, and also held that doctrine of arbitrariness is also impliedly present in the same way the doctrine of natural justice under Article 14. Now the third is doctrine of reasonable classification. So Article 14, it forbids class legislation, but it permits reasonable classification. Such codification this codification should go through two tests. The first is of intelligible differentia, and the second is of proper nexus or a link between the classification done and the purpose of the act. Like, when you are differentiating between two things under this doctrine, you have to see that whether there is intelligible differentia between the differentiation you are doing, and the second, there should be a link between the classification and the purpose of the act. Then you can do this reasonable classification. So there was a case of Ramakrishna Dalmia versus S.R. Tendulkar, 1958 Supreme Court judgment. It was held that the doctrine of reasonable classification and these two tests, the first one of intelligible differentia and the second one of reasonable nexus, they were provided in this case of Ramakrishna Dalmia versus Tendulkar. Now, there might be a few questions in your mind regarding this article, Article 14. So let's discuss them one by one. So first question can be, can Article 14 be amended? Yes, it can be amended by Parliament through constitutional amendment, but only on one condition, that you cannot dislocate its basic structure. You cannot play with it. You can amend Article 14, but you have to make sure that the essence of Article 14, it remains there. Now, second question that comes to your mind, it can be, does Article 14 confer absolute rights? So the answer to this is no. Article 14 does not confer absolute rights. It confer relative rights. So question number 3, it can be, are special courts permissible under Article 14? Like, can you differentiate between courts under Article 14? So yes, special courts are permissible under Article 14, but there should be a reasonable classification. Like, if you are establishing a special court for some particular reason, you should have a proper classification for that, for that establishment. Now, we'll go through some exceptions to Article 14. So first one is that like the people or the offices under law that do not get affected by Article 14. So the first one is the president and the governor. They both are immune from the ambit of Article 14 by virtue of Article 361. It is there mentioned in Article 361 that president and governor they both are safe from this Article 14 from the from this. Now the second one is members of parliament. They are also immune under Article 105. Third are the member of state legislature. They are also immune. It is provided under Article 194. Fourth are foreign sovereigns. They are also immune from this article. Diplomats and various people like diplomats, ambassadors, various ambassadors, and they are also immune. The main is United Nations and UN and its various organizations. They are also protected from this from the ambit of Article 14. Lastly, under Article 31C, Article 31C, it is also immune from the ambit of Article 14. Now let's quickly skip to Article 15. So Article 15 clause 1, it has various clauses, so let's get to it clause by clause. So Article 15 clause 1, it states that the state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Like you cannot discriminate against any citizens on these bases or the combination of them. Like you cannot discriminate between religion, race, caste, sex, place of birth, or any combination of them. Like you cannot also discriminate between religion, race, caste, sex, or race or place of birth, like any combination of them. Now clause 2, it says that no citizen, like the first clause it was for the state, the second clause is for the citizens of India. So it says that no citizen shall, on grounds of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to like you cannot discriminate the citizens on these bases with regard to access to any shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. So no citizen can be discriminated on these grounds. Now clause 3, it says clause 3 is an enabling provision and it creates a saving clause which enables the state to make any such discriminatory provisions for specifically for women and for children. So it allows that. So it is a saving clause and it is an enabling provision. Now Article 15 clause 4. Clause 4, under this clause, the choice was left to the state as to what policy it adopts to advance the interest of backward classes. Since it was socially and since it was based on the socially and educationally backward classes, so it has to be a social and educational advancement. So the policy was also the matter of choice for the state to choose to adopt the reservation policy, according to which the backward classes or the scheduled caste and the scheduled tribes would be given reservation in government schools and colleges in admission. So this was Article 15 clause 4. Now let's get to Article 15 clause 5. In this clause, clause 5, it was added by 93rd constitutional amendment in 2005 and it is a saving clause. This clause extended the reservation policy in educational institutions, which provides which also includes private educational institution, and the Supreme Court in the case of very important case it is of Ashok Kumar Thakur versus Union of India 2008 Supreme Court judgment. It was held that if the private institutions are earning profits from the society, then they have to bear the burden of upliftment of the society also. They cannot just take the profit and leave the people on their own. Now Article 15 clause 6. This clause was also added later on by 103rd Constitutional Amendment in 2019. By this clause, the provision of economically weaker section, we all know as EWS, it was added in this, and the EWS will be identified as per the notification by the state on the basis of family income and the economic indicators. So state will decide that what category of people will be there under the economically weaker section category. A maximum 10% reservation can be given to such people in admission to schools and colleges, and this 10% will be above the reservation provided in clause 4 and 5 of article 15. Like clause 4 talked about women and children, and clause 5 talked about scheduled caste and scheduled tribe. So the 10% that will be given to the economically weaker section, it will be above that, above the reservation provided in both the above clauses. So let's keep it till here, and further right to equality from article 16 to article 18 will be discussed in next video. I hope you find this video very helpful and hope you have a great day. Thank you.